Hello, everyone, and welcome to today's Lawpath webinar. My name is Ryan Tan, and today we're going to be covering launching an online store and the legal essentials behind it. So I'm going to bring Damon on, one of our lawyers on the legal advice plan. He's presented before on a number of topics, so we'll bring him on shortly. But just so everyone's coming through onto the webinar and joining, if you could just let us know in the chat where you're coming from and what industry you're in. And again, if there's any questions throughout the webinar today, feel free to pop questions in the chat. We do have a dedicated Q&A box that you can enter in your questions to as well. Okay, so I'm just going to launch a poll here. We're going to ask 5 questions on your business, because we do want to understand a bit about everyone on the webinar today and how we can make these webinars customized and valuable for you all. So I've just launched the poll with 5 questions. If you just could take a moment to fill those out and let us know about your business and your biggest focus in 2022. Perfect. Thank you for everyone filling in the poll. We'll just leave it open for another minute or two. But yeah, today's webinar will be going through launching an online store, the legal essentials. So we do have a lot of businesses who we speak to every day who are looking to start an e-commerce store, or they're looking to take their existing business online with e-commerce and sell their products online. And it's a very exciting journey to do, especially if you're a new business, but even if you're ramping up and scaling your business online, there are a number of legal essentials to consider that ensure that you're compliant. So we have a range of documents like our privacy policy and terms and conditions, but even more than that, there's more things to consider, such as intellectual property, and that you're complying with the Australian consumer law as well, with things regarding, say, returns and the like, to ensure that you're fully compliant. So Damon will be covering off all of those as well as the legal documents. And towards the end, we will have an exclusive offer for everyone on today's webinar as well, for our plans as well. So thank you for everyone who's filled out that poll. Now, just to go on to today's agenda. Now, we're going to be going through a bit about Lawpath. We'll be introducing you to Damon, and then we'll be going straight into starting an online business, the essential requirements, such as the legal documents and the obligations. And then towards the end, we will have a Q&A as well. So if you have any questions on the topic of an online store or e-commerce, then stick around to the end, because Damon will take your questions, and we will cap off with our exclusive webinar offer as well. So just a bit about Lawpath and who we are and what we do. We make smart, simple legal for small businesses, and our goal is to make legal more accessible for the average small business. As you can see through these stats here, we've saved 300,000 businesses over $100 million in legal fees, and we have over 10,000 5-star reviews on Trustpilot and Google. So we've got a lot of businesses that we're working with. E-commerce owners and online stores are definitely one of the biggest clientele as well, especially with changes over the last few years. More people are looking to make money online as well. So through our platform, you can create legal documents, manage compliance, and connect with lawyers on demand in one simple platform. Now, I'll just introduce you to Damon. He is one of the main lawyers on our legal advice plan. He's presented multiple times on our webinars. He's fantastic with over 14 years of experience, but he also has an experience in an array of legal areas, and he's a 5-star rated lawyer on the platform, being our top employment, startup, and commercial lawyer. So without further ado, I'll introduce you to Damon Murdoch.
Good day. Hello, everybody. Hope you're doing well. Hopefully you post a lot of questions in the Q&A, and at the end I can give you some guidance on your specific issue. So we'll get straight into it. So we want to look at what you need to do to start an online business. It's some of the fundamentals. I'm not an expert marketer. I'm not an expert business consultant, but I've seen thousands of businesses come through my door, and a lot of them are online businesses. So we'll just focus first on deciding what you're going to sell. So that's obviously more of a marketing thing, but you're looking at doing a business plan. A lot of people don't do one. A lot of people don't look at their SWOT analysis and doing their basic marketing that's necessary in looking at the target, looking at the audience, and looking where you're actually going to sell. And the reason why this becomes important when you're looking at what you're going to sell, what your competitors are doing, and who you're going to sell to is determining whether you're just selling to people in Australia, or whether you're going to do Australia, New Zealand, or whether you're going to do worldwide. And that's where the legal issues come in, because you can have terms and conditions, but if they haven't been drafted for you to sell internationally, then this really becomes an important feature of what you're actually going to use in terms of your payment gateway, in terms of your terms and conditions, dispute resolution processes, what the applicable law is, what the privacy is in those jurisdictions as well, and if there's anything else that you might be missing. So do a business report, have a look at who your competitors are, what they're doing, where they're selling, and look at the margin that you're actually going to make. Because if you are going international, you also got to consider possibly having a clause dealing with the change in foreign exchanges. So if you're buying a product from somewhere and then selling it online and the currency fluctuates, you want to make sure that if you're getting locked in on prices, you might have a clause that deals with the currency exchange rates, or a force majeure clause, which I can get into more detail later on. So the first thing that a lot of people do is they go to GoDaddy, they go to one of the providers to go buy a domain name. And then they go and they either register an ABN or get a business name. Now, the first thing I want to identify is that that does not protect your brand. So just because you went and got a business name that's ABC doesn't mean that someone else can't open up a company called ABC Trading, ABC Supplies, ABC Enterprise, ABC Corporation, whatever it might be. So your business name, when you register it, all that does is stop someone from having the identical name, but it doesn't protect you in someone else having a business that is trading under almost a similar name. What you need to protect your name is a trademark. And I'll talk about a trademark later, but the first thing is, if you want to get a domain name that's registered in Australia, such as a .com.au or .net.au, then in those circumstances, you need to get an Australian business number. And Lawpath, you can go to Lawpath's website and they can help you get an ABN. And you want to look at getting your domain name. Now, one of the things that a lot of people don't do very well is they start building their brand. They find someone on Fiverr or somewhere to build a logo for them, come up with your name, your slogan, start building the colors of your website, but they actually haven't done a proper search to see if there's anyone else out there that might already have that brand protected. And so you can go to the IP Australia website and type in IP trademark search and see if someone else has that trademark and might be using that brand already. You can also go to the ABN lookup website, and there you can just type in a name and see if there's anyone else that has a similar name to yours. So just because you got an amazing domain name doesn't mean that that's going to prevent someone else from getting the same domain name, being a .com, for instance, or .io, or whatever it is. So the first step, get the domain name, get your ABN, but also before you do either of those, you want to Google around, you want to do your searches, and you want to make sure that it's an original, because it's not only about protecting your brand, it's also about not infringing upon somebody else's. And you could spend all this money on Google AdWords and on Facebook marketing and so on, to only then discover you're infringing someone else and you get a letter of demand from someone. And as a result of that, you now have to change your name. So the next one is looking at, well, how are you going to sell your product? So there's a couple different ways. You can use the e-commerce platforms, Spotify or Shopify, BigCommerce and so on. Those are great ones to get you off the ground very quickly. But a lot of times when you actually look at the pricing model, sometimes it's a lot cheaper to just create your own brand and create your own website. And you got to have a look at whether going with the e-commerce platform versus customizing, building your own website, you got to weigh up a balance between which one's going to be a better option for you. A lot of times at the beginning, you don't have a lot of capital, you want to just get off the ground, then using an e-commerce platform is great because you get there right away, you've got a target audience, and it's a great way to launch your business, but also you're paying for it. And sometimes it's better just to build your own custom website. It also depends on what the products you're selling and what you're actually offering. So have a consideration to whether an e-commerce platform versus a custom website and which one's going to be better for you. Now, if you do go and build your own website, one of the most common disputes that we get for e-commerce businesses is actually the very beginning stages when they've hired someone to build a website for them. This is very, very common because either they've gone to a friend to help them build it, or they've gone overseas because it's a lot cheaper to get it done. And the problem is that if you just pay somebody in advance or 50% advance and 50% on completion, well, they've already got half the money. And if you don't have any due date specified or anything like that, then it can drag on and on and on and on. And that's where most of the disputes arise, is you've hired a friend to help build, they've got other paying jobs, so they've prioritized their work above yours, and then you can actually never get off the ground. Or you've created a website, but you actually haven't worked out what the architecture of that website is first. So a lot of the time you just sign up saying, okay, I'll pay this company to build a website for me. But what you actually haven't done is figured out in advance what the features are going to be, what language it's going to be, what your website's going to integrate into, so you know what language it should be written in, looking at the features, functions, and so on, and not actually wanting everything now. I think a lot of the times when people go build a website, sometimes they don't focus just on getting the minimum viable product. And the minimum viable product is get it off the ground. You're going to still have to do a lot of manual things, but at least you've got it off the ground and you can start developing your business, improving a market segment, rather than spending a fortune on developing a website and then trying to get it off the ground afterwards. And the reason why you want to do the minimum viable product is that you can get it off the ground. You can then start adding features while your business is trading, rather than waiting for someone to build a website and not actually ever getting off the ground because you eventually might get in a dispute with your web developer. But at the end of the day, one thing that I highly recommend you do is get a software development agreement or a website development agreement. And what that does is it breaks down a staged process saying, I'll pay you a small deposit. You're going to help me develop the functionality, the concept, the plan of what my website's going to look like. Once we agree to that, then I'll pay you another 10%, and you're going to build the actual layout and the UI and the UX, the user experience and the user interface. And then once we agree to that, then we're going to go and start developing the features. And it's a step-by-step process. If you just pay it all up front, or if you pay 50% in front, you could have a falling out and now you've just lost that 50%. So have a look at getting a software development agreement, website agreement, where the actual terms say that you're going to pay in stages. It's a progress claims as they slowly build with due dates and milestones, because otherwise it can get blown out in cost, time, you never get it to market, and so on. The next thing you want to look at is your website terms and conditions. So generally speaking, the website terms and conditions are going to be fairly generic if you're just starting out. And I always say it might not be necessary to get a lawyer to draft up a custom website terms and conditions if you're just a standard business selling goods online. But over time, you'll have some what we call pain points, which is you will see that there's customer complaints, things like that. And that's maybe when you want to talk to a lawyer to say, I'm having issues with these standard clauses. Is there any way I can fix this? And a recent example I found is that someone was selling dog merchandise or pet merchandise online, but people were putting in fake details and having them shipped to a post office. And it ended up, and then they were doing what's called a chargeback. So someone's bought the goods, they've received the goods, and then they've told their credit card provider that the goods are fraud, or the credit card's being wrongfully charged. And then the credit card company takes the money straight back. And so to prevent that chargeback, you might want to then also look into getting know your client, KYC requirements. So there's Green ID, there's Verify, there's different companies that verify the identity of your purchasers. It might not be necessary for the small products, but if you're selling products that are of a higher value, you might want to have some kind of threshold that's triggered. If someone's going to spend more than $300, then you might want to verify their ID before you sell them the good, because they could just use a fraudulent credit card, charge back, and you've lost the goods. Some other things you want to have a look at is your GST clauses, payment gateway, delivery terms, things like that. Now, if you're a gig economy where you're introducing a seller to a purchaser, sometimes you're going to be taking a commission of that transaction. And sometimes you're receiving the entire amount in advance and then issuing the invoice to the client. Now, it might be the case where you're actually selling the goods, even though you don't intend to be selling the goods. Because if you look at the flow of money, someone's buying the goods off of you, you're then introducing them to the supplier is delivering the goods to the purchaser. But if you look at the flow of money, you look at your contract terms, it might not say that. It might actually say that you're the one selling the goods and now you're responsible. So pay very close attention to what the actual terms say and what your actual process is in terms of money flow. So for instance, if you're just introducing two people, you want to say you're just a facilitator. The money you're receiving is actually just held for the supplier of the goods. It's not held by you. And you're just going to be taking your commission from that. And then you're going to be paying the rest of the supplier once the goods are delivered. And if that's the case, you got to then pay close attention to GST as well, because it might be seen that you're receiving all the GST and not on or passing it on, or it might be that some of your sellers on your marketplace, some might be registered for GST, some might not be, and you've got to sort that out now, because otherwise you could get hit with a large liability in the future if you don't get it right. Now, if we look at the advertising, and I'll get back to the actual terms and conditions in more detail coming up. Now, if we look at advertising, there's various different ways to do it. Again, I'm not a marketing expert. I've seen thousands of businesses and how they operate and how they grow. And I've done a lot of capital raising. We've done about 20 million in the last few months. But you want to look at the search engine optimization, social media, email marketing. And if you start doing that, the main thing is you're doing re-advertising or email marketing, you're looking at the Spam Act, and you got to be careful about how you actually are spamming people and how you're collecting their information. So that's where we're going to get into more about the legal side of things when you're collecting information and how you're using it and what you need to make sure you're doing to make sure you're not breaching the laws. So we'll look at the privacy policies. So in Australia, we have the Privacy Act and we have the Australian Privacy Principles, and that states where you're receiving personal information. So that's where you can actually identify a person. So if my name is in my work email, that's still possibly deemed personal information because it's my personal name. So where you're getting someone's name, age, sex, gender, whatever it is, email addresses, phone numbers, personal registered address, residential address, and possibly credit card. That's all going to be privacy. Now, if you're just operating in Australia, the Privacy Act applies. But once you step outside of Australia and start selling internationally, then it's likely that you're going to be falling foul to international laws as well. And the most common one is the GDPR, which is the European Union one. And a lot of people have looked to that as the most restrictive privacy laws. And if you're selling into Europe, then you're going to have to look at that. And then there's another one special for California, and there's different ones for the United States as well. But most of the times, if you're complying with the GDPR, then in that case, you're generally going to be covering most of the privacy laws around the world, because it says what you're collecting it for, who you're going to be sharing it with, why you're sharing it, and how you're going to use it, and the fact that the customers can actually contact you and ask for the information that you have on them. And one of the things is about sharing the information. So for instance, if you're using a delivery partner, well, you're going to be sharing the personal information with the delivery partner. If you're using a payment gateway, you're going to be possibly sharing the personal information with the payment gateway as well. So you want to have a look at your terms and conditions specifically to privacy and make sure that you're specifying how you're collecting it and how you're using it, and be detailed about how specifically you're going to be using it for delivery and payment terms and things like that. Now, again, if we go back to the website terms and conditions, the main focus is what we want to do is having a look at the intellectual property, making sure that anyone that visits your website is going to be bound by your terms, what people can't do when they visit your website, any warnings that you want to have regarding it, and what kind of limited liabilities or refund policies and so on. So the bare bone basic principle is that when you go to a website and you have to click to accept, that's called a click wrap agreement. And a click wrap agreement is legally binding. Now, the other way that you can get people to accept something is what's called a browse wrap agreement. That's not necessarily binding in Australia. So if you go to Lawpath's website and you don't have to click to accept anything, then it's possibly that Lawpath has their terms on the website, but if you actually haven't clicked to accept, they might not be legally binding on you. And that's because that would be a browse wrap agreement. And for a browse wrap agreement to actually be binding on someone, you have to use reasonable endeavors to let them know that those terms exist. And you need to make sure that they have seen them so that they are binding on those people. So a lot of times you might have an invoice where it says at the bottom, by accepting this invoice, you're accepting our terms and conditions found on our website. And by making payment to us, this indicates your acceptance of our terms and conditions. Generally speaking, if that's in bold and very identifiable, then even though it's a browse wrap agreement, it can still be binding because you brought it to someone's attention before they paid you. We also see sometimes where people sell a good, and then in the delivery docket, when the good arrives, they have their terms and conditions there. That's not any good to anybody. And the reason it's not good to anybody is that you can't impose terms and conditions on someone after the fact. You can't impose terms and conditions on someone after they've already signed or paid you. So you need to make sure it's brought to their attention before they've bought the good or bought the service. And normally you do it by way of a click wrap. They're clicking to accept before they actually pay you or sign up to your service. Now, if we look at the terms and conditions in more detail, we want to look at, this is where most people have issues. Now, I can see a lot of people are putting comments into the chat. Can you resubmit those comments into the Q&A? Just because we're only going to be looking at the Q&A if you have questions and you want me to answer those. So if you've put something into the chat, put it again in the Q&A and I'll go over those at the end of this presentation. Now, if we look at the terms and conditions, this is where most people have problems. It's because they have used the template, and there's generally nothing wrong with a template if you have a standard business, as I mentioned, but it's where you've actually spelled out what you're doing or what you're selling. That's normally the issue. And you have these things called Australian guarantees, and those are in Schedule 2 of the Competition and Consumer Act 2010, which is what most people know as the Australian Consumer Law. And the Australian Consumer Law gives these guarantees. So if you're selling goods, you're guaranteeing the good is of merchantable quality. You're guaranteeing that it's going to be fit for purpose. You're guaranteeing that it's going to match the description. So if you ever hear about people wanting a refund because their microwave broke down within 3 months, the company might not have a 3-month warranty, but it's implied by Australian consumer law that it must be of merchantable quality. And then you got to look at, well, what is that guarantee? What's that warranty? Well, you got to look at the facts and circumstances of the case. And generally, electronic goods should have around at least a 1-year warranty. And most goods have a 1-year warranty. But for instance, if you're selling clothes, they don't necessarily have to have any warranty unless unless they don't match the description. So if you say what size they're going to be, and then someone buys them and they don't fit them, and they don't match the dimensions specified on your website, then you're probably going to have to give them a refund because it doesn't match the description for which they were sold, which is a breach of an Australian guarantee. So you got to make sure that you're spelling out the terms very detailed, or the goods on your website very detailed in what they are, what the size of them, what they're used for, things like that, so that people know exactly what they're getting when they buy it, and it matches the description that you're given. And normally it's a lack of communication of what leads to most legal disputes. And the lack of communication is because the details on the website weren't specific enough about what they are going to get, what they're not going to get, and what the description of the goods are. We also look at the payment procedures. Most people these days use Stripe or another similar marketplace or payment gateway. What you want to do is make sure that in your terms, you say by buying the goods, you're going to be agreeing to use our payment gateway. And when using our payment gateway, you're going to be agreeing to their terms and conditions as well. And we can share your details with them. And the same thing goes for the delivery of the products, and then spelling out your refund policy. So if you are selling clothes, for instance, or you're selling a good, sometimes you might not be able to refund it for a change of mind. And you want to mention that. You can't refund a good simply for a change of mind, or you can't refund a good after you've opened it from the box. But the laws generally around refunds is if you do have a refund policy, then you got to spell out how to do the refund. So what are the conditions of your refund? In what circumstance can they claim it? How long can they claim that for? And what's the process? What's the email address? Do they send you the material? Do you send them a replacement good? Do you fix the good? And having a look at who's paying the shipping costs. Do they pay the shipping costs to you and then you resupply it back to them? Or do you pay the cost for them to bring it back to your warehouse and then you pay again for it to be reshipped? So you got to look at that. And then the last one is limited liability. And when you look at that, there's something called an exclusion clause. And I'll get to that in another slide, but you can't just say, I'm not liable for anything. That's against the Australian consumer laws, and it's generally against law in general principles already. So you can't exclude your liability completely. That's called an exclusion clause, and that clause is not going to necessarily be legally binding. You still put them in though, because they still give you a defense, because those clauses can be used potentially to give you a defense on how much your liability is, what part are you responsible for, what part are they responsible for. And a good example was a case in Victoria about someone signing a waiver when they went skydiving, and when they came down and landed, they injured themselves. And in that case, the court found that that waiver was legally binding because they knew it was a risk, they assumed the risk, and they signed a waiver that was very, very detailed in what they do cover, what they don't cover, what their insurance covers, and so on. Now, getting into the intellectual property and protecting your brand, this is where trademarks generally come in. So copyright is anything that's in writing. So the content of your website, the description of your goods, maybe even the look and feel of your website, the tabs and things like that built into your website, that's all copyright. And that's automatic. In Australia, the minute you put it on pen to paper or type it into your computer, you own it. And if someone substantially copies it, that will be copyright infringement. What you do have to do is prove that you're the one that created it and it's an original piece of work that you didn't get from someone else. And you can prove that you created it before they did. So if you do, normally you can prove it because you have emails going back and forth between you and your web designer with the content you've drafted, things like that. But have a look at trying to have a record of when your copyright was created, so that if someone did steal your website, steal your idea, steal the content, you're able to show that you've created it. The next one, though, and the most important one, is probably trademark. Trademarks, they protect you in a specific class. And what they do is they can protect a word, the name of your company, your slogan, or even your logo. And it depends on what kind of trademark you get, but it only protects you in the class of goods or services that you have lodged your application in. So I normally use this example of a company called Barefoot. Barefoot made a beer. There was another company that made footwear. And the company that made the footwear, Barefoot, they lodged an application in the class where footwear is in. And then the alcohol manufacturer they lodge an application in the goods where alcoholic beverages go in. So that means that no one else in alcoholic beverages can sell a product called Barefoot. And no one else in the shoe industry or the footwear industry can use the words barefoot. But what then happened is that then they start crossing into other industries, t-shirts, merchandise, things like that. And it becomes a question of, well, whose trademark now has the priority? And so it's the first one that files generally will have the priority. So if you are creating a brand and it's a new brand and it's an original brand, then you want to go and get a trademark right away. The only problem that you're going to have is that if your trademark is too generic, so you can't lodge a trademark called taxis in the taxi class, right? So you got to have something that's fairly new, original, and not a generic word. And if you are going to use a generic word like footwear, then you're going to want to call it Jane Doe's footwear, or you want to elaborate on it so it's more specific and it's an actual brand that can be protected. The second one is after you've lodged that trademark, you need to use it as a trademark. If you're actually not using it or you're using it slightly different to what the trademark is recorded as, then you're not using it as a trademark, and someone else can come along and file an application, which is called a non-use application, and kick your trademark off the register because you haven't actually been using it as a trademark. So if you say, you know, I'm selling a beauty clinic selling whatever it is, and you don't actually elaborate on it, or you change your name a little bit, then you might not be protected anymore. So that's just about trademarks. Getting it protects your brand, and it's important, and I recommend you get a trademark, especially if you're in the retail industry selling and your brand is actually really important to what your goods are, because it adds premium or whatever it might be. And then the other one is looking at protecting your intellectual property. So again, with your web development agreement, for instance, you want to own your website. So you want a clause that says in your contract that you own it. If you get a logo created, you want something that says you own it. If you hire a contractor to do anything for your business, content writing, even Google AdWords or anything like that, you want to own the intellectual property, and you don't want someone to come back later and claim some royalty that they're owed against you later on for reusing their information or their copyright that they've created. So you can get an IP assignment deed, which is going backwards and say, look, I forgot. Can you just confirm I own the logo that you created for me? Please sign this IP assignment deed. And if it's someone in the future, you normally want to get a contractor's agreement or something along those lines that says that you own the intellectual property. Now, when we want to look at the different problems that can occur, a lot of people don't start their business until they've actually got it off the ground. So a lot of people will start building their business while they're still employed somewhere. And the problem with that is that if you build a business while you're employed somewhere else, and especially if it's similar or might be more niche than what your current employer is doing, but it might be similar in many respects, or it might be an idea that you came up with while you were employed, and then your business goes and becomes very successful. Your employer could potentially come back and sue you and claim ownership of all that intellectual property. And the reason is if you look at your employment contract, a lot of them says that any invention that you come up with while employed is owned by the company, or any intellectual property that you create during office hours are owned by the company, or any information that you create using the company's materials, such as their laptop, is owned by them. You want to be very careful about creating that and not falling foul later to your employer coming and suing you and claiming ownership of everything. It's probably most particular in intellectual property like cybersecurity, data analytics, managed services, any of the more sophisticated tech companies. But you also want to look at retail as well if you're in the retail business, because you might be selling one product, you might have discovered that there's a huge margin and a huge opportunity for this other product, which is very similar, maybe from the same supplier, and then you start going and doing that, you could get a lawsuit. So be very careful. If you're going to do it, look at your employment contract, maybe get advice on your employment contract, do it outside hours, buy your own laptop, don't use your company's laptop. Don't do it on the company hours, don't do it in the company or your employer's office. And then talking about making sure having a contract of anything you do, you got the Zuckerberg case. Most people have seen Social Network, and that's exactly what happened. They didn't have a contract, and that was what actually ends up happening. Is if you don't have a contract in relation to your intellectual property, these are the issues that can arise, similar to the Facebook situation. Now, when you look at the Spam Act, very basic, I won't get into too much details about it, but high level is if you are sending emails, if you're capturing people's email address when you're doing a Google ad or a Facebook campaign, or just any kind of, even on your website, if you have Inquire Now or whatever it might be, if you're catching that data, or if you're sending emails, then you need to make sure that there's an unsubscribe link. You need to make sure that you have your details at the bottom. And then this is again important about how you actually got their details. So you might want to mention in your privacy policy how you got it. So you might say that we have cookies on our website. You might want a cookie policy. You might want to put up policies wherever you're actually doing this so that they know how you collect the data, but at the very least, they're able to get out of those emails. Most of the time, MailChimp and similar to those are already compliant, but just make sure if you're doing it yourself, you are compliant. We then have PCI Compliance. These are when you're actually collecting credit card payments and whether you're actually doing it yourself. If you are, there's very strict measures on how you actually keep credit card information. So if you were to just have a form and take people's credit card details over the phone and write it down and keep it in your system, and your system gets hacked, you could be up for a lot of liability if you didn't protect that credit card information. So generally speaking, most people will have a payment gateway, maybe take credit card details on the phone, but they're actually not plugging it into their own system. They're plugging it into a payment gateway that is PCI compliant already. So, but if it's not, and you're collecting the details yourself and processing itself, be very careful about keeping that information and where you keep it and store it correctly. And then when you're looking at collecting payment terms and the payment gateways, you're looking at PayPal and Stripe and Braintree and things like that. Make sure they're all PCI compliant, but make sure when they're using your website, you're making sure that you spell out that they are accepting their terms as well. And I've had a situation where people have just said we're using Stripe, but then 5 years from then, they're not using Stripe anymore. And then people say, well, I never agreed to your other provider. So you want to make your terms fairly generic by calling it a payment gateway rather than Stripe specifically. Or if you're using Stripe, you want to then make sure you update your terms if you change it. When you look at Australian consumer laws, a director can be personally liable in certain circumstances, and that's such as misleading and deceptive conduct. So if you're on the phone, you're telling people this is the best product in the world, it's going to last forever, whatever it is, they buy it, and it's not, can then sell or sue you personally and your company for misleading and deceptive conduct. And the basis for that is that they relied on a representation made by you, which was likely to mislead or deceive them. They relied on it. As a result, they suffered damage by buying the product. So those are the key situations where you can have personal liability. You'd also have fake testimonials. There has been a rising number of cases. The Australian Competition Consumer Commission can get involved for fake testimonials, and people can sue for misleading, deceptive conduct. You held yourself out as having 200 5-star reviews, but you actually just paid somebody to give you those reviews, and they're actually not customers, and your product's actually crap, right? That's the reality of, if you have fake testimonials, you're opening yourself up to liability. The other one is unconscionability. You can't just make terms that are just so unfair. A lot of times you have your online terms, that's called a standard form contract. People don't have the opportunity to negotiate it. So generally you can put what you want into those terms. The problem is that if anyone ever wants to contest those terms, they can be found to be unlawful. And it could be a situation where they're not binding at all, and you now don't have any terms to protect you. And the main one is unfair contract terms, which is Australian consumer law, which is between section 23 and 26 of the Australian consumer law. It says, well, is there an unfair bargaining position? Was it a standard form contract? Did people have an opportunity to negotiate those terms? Do the terms give you a lot of ability to terminate the contract, but them none? Are you putting them into an automatic renewal clause without telling them when it renews, or putting them in automatic renewal terms, and then they can't renew, or they can't cancel unless they give you a certain amount of notice? These kind of clauses are becoming more likely to be unenforceable because they have to protect a legitimate business interest. And recently, Fujitsu Xerox was just found to be found that their terms were unenforceable, and they had to give an undertaking to the ACCC saying that they're not going to enforce those terms against any of their customers for the next few years because they were unenforceable. And there can be damages associated to that as well. And that's about it on terms of Australian consumer law. And that's all I have for now. And we'll get into the Q&A, and we'll answer your specific questions in a moment. And I'll go back to Ryan.
Perfect. Thank you so much, Damon. That was a really comprehensive overview of building an online e-commerce store and the legalities behind it. So just recapping back to how Lawpath can help, we do have a few services such as contract management for your business. So a lot of what Damon said, and a lot of those policies like privacy policies, website terms and conditions, and the like, refund policies and shipping policies, they're all available as templates through our platform for you to download and create. We do have personalized workflows. So we do have a specific one on building a website and an online store, which again would populate, would populate some agreements. If you're collecting payments online, if you're doing referrals and also affiliates. So that one's available for you to access. And then lastly, booking in legal consultations as well. So again, if you have specific queries that have arisen today from the webinar and you want to get some legal advice on specifically to your industry, it would be great to book in a legal consultation. However, if you do also want to get these documents reviewed, perhaps you've got a privacy policy or a website terms and conditions in place, and you want to ensure that it's compliant with the consumer law, then again, we do offer contract management on these plans as well. So one other thing that we're doing at the moment is our legal health check. Now, this legal health check is good if you're a new business starting out and you want to understand where you might be sitting in different areas of your employment and contractual agreements, as well as your website terms and conditions, and more importantly, on intellectual property. So if you're interested in this one, definitely make a comment in the chat and I'll reach out about completing this one. Now, just a few of our plans. A lot of you would be aware of what we do have and what we offer, but we do have our essentials plan on the left. It is a legal documents library. We have now 362 documents and growing, and we're continually updating these. We have our legal advice plan, which is our essentials plan with the legal advice. So you do get unlimited 30-minute calls each month on new topics. With our lawyers, such as Damon and a bunch of other lawyers on the platform, which we do also offer legal contract review up to 4 pages as well. So it can be incredibly helpful to get the documents you've made reviewed, or if you have documents elsewhere, we can look at those as well. And then lastly, our legal and accounting advice plan. So if you do have accounting queries, particularly around, say, an online store and accounting for that, or GST, or paying yourself as a director, these are great topics to speak about with our accountants. So that plan does include the essentials and legal advice. On top of that, it does include ASIC and ATO agent service. So if you do require company changes to be made, we can be your registered agent for ASIC and the ATO as well. So for an exclusive webinar offer, what we have today is we're offering 20% off our legal advice plan. If you feel that you'd love to be able to get some legal advice, you've heard Damon speak. I know we've got 30, 40 plus questions here, which we probably can't get to all of them today, but there's some great questions on very specific industries, and you'd like to speak to Damon or some of our other lawyers and really ensure that you're staying compliant, then we're doing, again, 20% off the legal advice plan. So it's $100 a month. Now, the good thing is that on our website, this plan is normally $120 a month and it's billed annually. But what we can do for everyone on the webinar today is not only do you get 20% off, we'll put monthly billing in place for you as well. We do have a 3-month trial to our legal advice and accounting plan as well. So if you do need some shorter term advice or you want to try out the plan, then that one's available to you as well. So if you're interested in either of these offers or simply just our essentials plan, comment yes in the chat, and one of our team will be in touch with you this afternoon on redeeming this trial offer. Cool. So that's reiteration, $100 per month for this one, monthly billing with an annual commitment, and you can get legal advice and contracts review as well. Also, I'll pop it over to Damon for some Q&A. We probably have time for about, say, 5 to 10 questions.
All right, not a problem. So the first question we have is from an education consultant. It's not uncommon where people have a website, but they don't actually take payments on their website. So they might have articles, information about themselves, might be giving some advice on their website, blogs, things like that, but there's no tick to accept. So it might be that you're capturing their data because they might have clicked on your Facebook advertisement or your Google ad, or they might have gone to your website and put some information in, but there's no click to accept. So the question is how do I actually get them to agree to our privacy policy or our terms and conditions? And do we actually need terms and conditions at all? And the answer is, again, you're going back to the browser app scenario where you should have terms and conditions on your website. And those terms and conditions don't need to deal with money at all. Doesn't need to talk about delivery, but for instance, if you have articles on your website, you might want to say the content on our website is general in nature only. It's not specific to your needs. If you need specific advice, please contact us. Our articles are based on the date that they're published, and they might have expired. If you are uncertain whether it's old information or it's new or whatever it is, then please make sure that you get more specific advice from us by contacting us and blah, blah, blah. There's nothing more than you can do other than have your terms and conditions on your website. You can put a little star, and that's what you always see in magazine advertisements and things like that, where it just has a little star that says subject to our terms and conditions on our website. So there might be a way that if you have a brochure, for instance, but you can't attach the terms, you just put a link to your website, put a little star there, or it's just general knowledge that if someone's going to your website and there is a tab at the bottom that says legal terms, you will probably have a good arguable case that those were generally, it's general knowledge that the terms were on there. They were able to read the whole website, get information from it, and now they're suing you, but they never read the terms. So I think just generally, you should have terms on your website, but they don't have to deal with all the specifics about buying the products and things like that. But it will cover, you own the copyright, the information is general in nature only, and so on. Now, let's have a look at the next question. So I have an online business. My customers are mostly in the US. Do I need a trademark registered in the US or Australia? So that actually gives two questions, or there's two questions there, is doing business in the US. So I'll give you a 30-second spiel on doing business internationally. There's something called the New York Convention, which has been done by the United Nations. It's the New York Convention for the Foreign Recognition and Enforcement of Arbitration Awards, 1958. About 152 countries around the world have signed it. And it basically says, if you're going to do businesses internationally on commercial terms, the parties can mutually agree to the applicable law and where that law is going to be resolved. So you can say in your terms and conditions that the applicable law is Australian law, and the location of the dispute, if there is ever a dispute, is Australia. Now, an arbitration clause can then be enforced in all 152 countries around the world. So if you're doing international law, international business, you should consider getting an arbitration clause, not a clause that says that Australian law is the applicable law and then you go to court. You want to be saying that you go to arbitration, and that falls under the New York Convention. And you can just Google the New York Convention and have a look at that to find out more information about it. Now, in terms of the trademark, your trademark's only good in Australia if you have it registered in Australia. And if you are doing business in the US, you'll need to get a trademark there. A lot of people go and register straight in the US, but the problem is that you actually have to show usage in the US to maintain your trademark. So one of the things is you want to, if you are going to go to the US to get a trademark, then make sure you start using it first. Otherwise, you're going to pay all these filing fees and never actually be able to keep it. So we have a business through a website. My customers are mostly in the US. Oh, that's the same question. Let's see if I can, I have to get Ryan. All right. So one of the questions are, what's the limitation of the trademark registration in relation to class 41? Can't tell you, it's very specific. So we would probably have to go through each, well, I'd have to pull up class 31 or 41. I don't think anybody knows all the words that are in there and all the goods and services that are specified. So I can't give that advice, unfortunately. So we have someone that's created a website. So they said they created a website. What other platforms would you suggest to use other than GoDaddy that are user-friendly? I can't really recommend one over the other in terms of what provider. Your probably best bet is the Google search. Lawpath does have a bunch of really good partner offers as well. Each one of those partners have been carefully scrutinized by Lawpath. So if you do sign up to Lawpath, you can then see all the partners offers. I think there's around $10,000 worth of offerings if you sign up, like MYOB and GoDaddy and a bunch of other ones. So you might want to look at that. But I also recommend just talking to friends and family and getting good recommendations from people, what they've used, and find out what is best for your needs. And it's really doing your own research. I'm just trying to get to the next one. One of the questions is it better to trademark a logo or a word? Generally speaking, you want the word, because the word is actually going to stop anyone else from using that word. The logo is normally original. In those circumstances, because it's original, it's generally unlikely that someone's going to use the exact same logo in the exact same industry as you. So one of the things is, but if you want to protect your brand, I would always start off with the word first, because that's going to give you the most protection, stopping anyone else from using that word. Once you've developed your brand, or if you have sufficient funds, or then file another trademark with your logo. And you can also do a composite, which is your logo and your word. So if it is not specific enough or too generic, and you might not be able to get it across the line because it's something that is commonly used, then you might be able to get across the line by doing a composite, which is your logo plus your word. All right, well, I think that's it. I'm gonna pass it off to Ryan. Thank you very much for attending.
Thank you so much, everyone, for your questions and for attending today. We do have so many questions that have come in, and rightly so. This has been it's a very interesting area that's evolving over time. Changes in consumer laws, changes in compliance. So again, all these questions that we couldn't get to today, they'd be perfect for the legal advice plan, and with the offer that we've got going on now, it really is a no-brainer. Just to touch upon that one as well, we do have an accelerator program available on the legal advice plan. So Damon and the lawyers, we've got 6 different topics that we can go through to ensure holistic legal compliance, from everything from, say, employment agreements to privacy policies to insurance, and all the way to capital raising and preparing you for that process. So again, if anyone is interested, I'll put that offer back here as well. It's $100 a month. It's cheaper than what you see on the website. So it's an exclusive webinar offer that our team can only apply from our back end. So again, please key in yes if you're interested. We do have the details on file. But thank you to everyone for attending this webinar. I'm just going to pop up a feedback poll as well. We'd love to collect feedback and see what you found valuable from the webinar, and then also what we can do to improve these webinars moving forward. So if you could just take a moment to fill out this feedback poll, that would be fantastic. And any other questions or queries, feel free to key them in the Q&A or the chat box now. But thank you everyone for attending and for your time today.